So good afternoon. Thank you, Kelly. If you don't recognize our smiling faces from yesterday, my name is Amber McGee and I'm joined by Sarah Robinson. And we are both VOCA funded attorneys with Philadelphia Legal Assistance, or PLA. And today we're going to talk about family law kind of overall in a broad sense. There is a lot of material, so if we don't get through all of it, you do have the PowerPoints, so you can see all of the topics there. And so today we'll be talking about custody, protection from abuse actions, a little bit about child support, and also programs for victims of crime. So as you can see, it is a lot that we're covering, but we're trying to keep it pretty broad. If you have any questions or want to chime in, feel free to either unmute yourself or type it in the chat box. We will be monitoring it. And you can also find our contact information on the last slide. If you'd like to reach out and chat with us, we do like to chat. So with that, Sarah will start with custody.
Thank you. All right. So before we dive into the specifics of filing, we need to go over the key definitions.
Let's go. Let's go.
Lisa, can you mute your microphone, please? Thank you. There's two main types of custody in Pennsylvania. A parent has the legal authority to make decisions about the child's life, including medical care, what religion they practice, decisions about their education, and other major life choices. Those all fall within a parent's legal custody right. The other one is physical custody, and that's where the child actually is and who the child is spending their time with. We have primary physical custody. That means the child is spending more than 50% of their time with that parent. There is a doctrine established in this case that we have cited here that the primary custodian, the child should not be taken away from the primary custodian. The primary custodian should not lose their status without a clear and convincing evidence that it's in the child's best interest to swap them and take them from the primary custodian. And then partial custody, partial physical custody is the type of custody a parent will have when they have less than 50% of time with the child. And partial physical custody can include types of custody like supervised visitation.
So a lot of our clients don't understand these definitions. They say they want things like full custody, or they want someone's parental rights taken away. So I think it's important that we go over at least what legal custody covers and what physical custody covers with our custody clients.
That's a good point, Amber. And I do hear a lot, I want their rights taken away. Custody litigation is separate and apart from termination of parental rights. That typically happens in a dependency proceeding or an adoption proceeding, but that's not what we do under the Custody Act. Another type of physical custody is shared physical custody, and that is 50-50 equal physical custody, or more than one person having substantial time. In some cases, there are more than two parties. For instance, I have a case right now where I have maternal grandmother, paternal grandmother, and the biological mom all sharing periods of physical custody. The next definition is supervised physical custody or supervised visitation. There's different avenues you can go down when it comes to supervised. You can designate a supervisee within the family or a friend, or it could be a third party agency who does that. I know there are several agencies throughout the state who provide that service. Unfortunately, the agency that provides the service for supervised visitation in Philadelphia is our very own family court. And we have a court nursery. Typically visits were happening on
I think
Sundays. You hear me still?
I can hear you. I just got a notice that says my internet connection is unstable, so hopefully it becomes stable.
Oh no.
I can hear you, Sarah.
Okay, great. So it occurs at the court nursery, but now that the court has been closed for over a year, people haven't been having visitation in the courthouse, and it's really been a massive just blank space when it comes to this service. So you do need to provide a valid justification for why you're asking for the custody time to be supervised, and typically there are major safety concerns about the child being with the parent. Okay, so who can file for custody? We are talking about civil lawsuits here, so you have to meet the threshold standard for standing, the right to file. Parents, biological parents, have automatic standing for custody. If you are living in the same household as parents, the order is not enforceable until you are living separate and apart. So you can get a custody order, but as long as you're under the same roof, it's not going to be enforceable. And this case here lays out the factors that the court will look at to determine, are these people in fact living separate and apart? Non-biological parents can file under in loco parentis, or in place of a parent. They must show, again, with clear and convincing evidence, that they have assumed the parental status, they have held themselves out in society, at the child's school, to the child's doctor, that they are a parent, or taking care of the child as a parent would. They have to actually discharge those parental duties. They need to not only, be out there in the world saying I'm this kid's parent, but actually taking them to school, taking them to the doctor, feeding, bathing, supporting, acting as you would as a parent. And their involvement in the child's life cannot be in defiance of the parent's wishes. So by the time that someone with in loco status is filing, perhaps that relationship has fallen apart. But the key is that the initiation, the origin of their relationship and their involvement in the child's life was done with the consent of the parent or parents. Again, parents have a prima facie right to primary physical custody if they are being sued for custody or defending a custody action against a non-parent. The court is going to presume or have a presumption in favor of biological parents that the third party must overcome. And one of the seminal cases for third party standing is this Jordan v. Jackson case here for your reference. As I mentioned, when you have multiple grandparents and parents, you may run into a case where a grandparent is filing for custody and not looking for primary, or they may not fall under the loco parentis doctrine. They must meet these standards, which are their grandparent whose relationship with the child began with consent of the parent or under some court order, perhaps a dependency order or even a custody order. They are a person who assumes or is willing to assume responsibility for the child, and the child is dependent or is at risk of neglect or abuse by the parent, and or the child has resided with the grandparent for at least 12 months. So there's a lot of specifics here, and it's very fact specific. You want to make sure that you are meeting each of the necessary elements for grandparent standing. Also, a couple of years ago, another version of third-party standing and more nuances to it were added to the law. I think that the motivation behind it was because of the opioid epidemic, and parents, who have fallen victim to that, who are unable to provide care for their children. This was added as a way for a caring adult who's familiar with the child and familiar with the family, but perhaps not a grandparent, maybe a different family member, or someone else who doesn't quite meet the in loco standards, to file for custody. Again, burden of proof here is clear and convincing evidence, and they are similar to the in loco. You must show that you have assumed or are willing to assume responsibility for the child and take over those parental duties. You have to show that you do have the child's best interests at heart and that it is sincere. It's not about getting, the benefits related to the child or some other motivation. And you have to be able to show that neither parent has any form of care or control over the child. Again, that can be very fact specific. It's not just about parents who, are suffering from opioid addiction or some other addiction. Perhaps it's incarcerated parents or deceased parents. So there can be any combination of facts here. Okay. Initiating a custody action always starts with a complaint for custody. And you want to lay out in there what exactly you're seeking in terms of legal custody or physical custody. Often I find in looking at complaints that were filed pro se that folks either don't specify at all, or they will be putting sole, or some other combination that doesn't actually reflect what they're seeking. So it's a good practice tip to always clarify what your client's goals are, especially as Amber pointed out, folks don't really understand all the time what the different terms mean. And they say they want full custody. Maybe they actually really just want primary and they're okay with the other parent having weekends. So it's really good to clarify the terms again. You can get an IFP for filing the complaint. There's two ways you can do the IFP. I'm sure it's different or similar in your county, so no need to go through that. But once the person has an IFP associated with their docket, that will stay with them for the remainder of the case. Parents who are minors, who are not adults, can file for custody on their own. And any father who is filing for custody, that's a de facto presumption, or that's a de facto assumption of paternity. Either they must fill out an acknowledgement of paternity ahead of time, or they cannot raise it as an issue later after having filed a complaint. All right, so once the complaint is filed, it will go in front of a custody hearing officer. And depending on what is requested in the complaint, you will either have a hearing with the custody officer or just a conference. So I explained it to clients that this is the first stop in custody litigation where the court tries to see if you can work out an agreement. If an agreement is possible, then the custody hearing officer will issue a proposed order, and then within 60 days of that order, litigants can file exceptions. If they have no exceptions, don't want to change it at all, it becomes a final order of court. That would be the fastest way to get a final order for custody aside from a stipulation. Typically, though, you get to, if the parties are fighting over primary physical custody, you will just have a conference with the hearing officer where they will essentially triage what custody factors are at play, whether any additional reports or investigations need to be initiated, if the court needs to order records from DHS, or if the court wants to do home investigations. And so it's almost like a status or a calendaring date. If it is a conference, there will be no testimony taken. If it is a record hearing, testimony will be taken.
And sorry to interrupt, Sarah, but every county is different, right? So I know in Allegheny County, we would have an educational seminar. It used to be that parties physically went to the courthouse for this educational seminar. Now it's just a packet that they may or may not read. And after that, they had mediation and then went to the hearing officer. So of course, just, be familiar with your county's procedure and the nuances too since COVID.
That's such a good add-on, because earlier today I was in a meeting where we were talking about the one judge, one family proposal. I believe a state representative has proposed some legislation for a constitutional amendment to make that uniform across Pennsylvania. In Philadelphia, we do not practice one judge, one family, which is an idea that a judge can become familiar with the specific family and the children, so that there's not so many different and sometimes opposing judgments in one family in one child's life. But yeah, they practice one judge, one family in Montgomery County, so I feel like that procedure is completely different. But what's the same are these custody factors. These are the factors, the elements that the hearing officers and ultimately the family court judges will consider in making their determination of custody. And not every factor is going to be relevant in every single case. I make sure I tell my clients about that, and I do provide them with a copy of this list, and I say, let's go through this together, and you tell me, what you think is relevant here, what you think you don't need to argue about. And in some cases, every single factor is at play. So hopefully you've been kind of perusing them while we've been talking, but they include, there is a catch-all at the end, which is important because I always find it interesting, like, who came up with this idea? How did we just decide these are the 16 and that's that? But so it's things like which parent is going to be encouraging of healthy relationships with the other parent? Does the child get to enjoy sibling relationships with one parent versus the other? The availability of extended family. So ideas about enriching the child's life and nurturing the child's emotional needs. Other things are relevant, like how close do these two parents or these two parties live to each other? Is it realistic for us to be putting a 3-year-old in a car for 2 hours every 3 days or something like that? So it is important to think about all of the logistics of a custody schedule. And then, of course, some of the more serious issues are obviously relevant, like domestic violence, history of abuse, the level of conflict between the parties. They have to have a willingness and show an ability to cooperate as one of the factors to share legal custody. And that was in the Yates case that we had up on the legal custody slide. Drug use, alcohol use, and mental health issues, they're all very relevant to deciding custody. The court should not be considering, however, how old the parents are, who the parents like to sleep with, whether or not the parent is in the country legally. Things, I have clients that do get upset about, this is their former intimate partner who knows certain things about what they like to do privately as a private adult. And there really is a gray area there where, you certainly want to advise your client against obvious and wanton like alcohol use, but if your client is concerned about having like a glass of wine out at dinner, you can let them know you're still allowed to do adult things. And information like that shouldn't be coming into a custody hearing absent any, major concerns or legitimate concerns about alcohol consumption. And then obviously, since we work at a nonprofit, a lot of our clients are concerned that the court will award custody to the parent who earns way more money than them. And they're concerned that their poverty is going to be held against them. And that's absolutely not true. If anything, I just immediately file for child support. And as soon as I hear that they've got deep pockets on the other side, let's go file some child support. But that's not a factor as long as the parent can, provide a safe home for the child, and the children are fed and the utilities are working. Then there should be no difference between, a parent that makes money versus a parent that doesn't.
But in the same vein, judges are human, and unfortunately, they do often have their own prejudices. So, always remind clients to keep an eye on what they put on social media, especially if the other party is friends with them or following them, just as easily as they can print out something that shows some bad behavior, the other party can do that to them. So I'd always just keep an eye on that, even if it's something they shouldn't be considering. If it comes out in court, even if it's thrown out because it's irrelevant or whatever, the judge still saw it. And unfortunately, it can affect your client.
Absolutely. I always advise everything you're putting on here, whether you have the right to or not, it is just imagine it's going to end up in court. That's a principle I live my life by. So it is good advice. We got a question in the chat about whether lack of employment authorization has been an issue. I have not personally dealt with that. And, given that courts are not permitted to consider, judges make decisions all the time that are not, within the confines of the law. But I can't imagine why that would become an issue unless the parent is unable to provide adequate care or make sure that the child's needs are met. I don't know, Amber, have you seen that?
I have seen that. I actually have a case right now where that's an issue. But I think, again, what I'm doing in that case is filing for support. So, and the client luckily is very well connected with community supports too. So that helps. So unfortunately, if you have a party bringing that up and kind of using it against your client, I think what you need to do is just highlight things that they are hopefully doing that can help them show that they can support the child, financially too.
And then this last piece here, it says that the court they have an obligation to give their reasons for why they're awarding custody to one parent or the other on the record or in a written opinion. If we could take a poll, how many people think this happens? Some judges do, and it's lovely. They will go through factor by factor and say, this one I lean for mom, this one I lean for dad, and really show you what that weighing balancing process is like. And then others may include it in their order, or sometimes you don't get any real clarification at all. So it's a good idea to ask the court, put their feet to the fire and say, I'd like to, put on the record the court's reasoning and weighing of the factors, which factors were most relevant here. All right, special issues and motions. So if a parent has a criminal conviction, you're going to want to check section 5329 and see whether or not the conviction is included on this list of crimes. If it is, the court is further obligated to undergo an analysis of whether this person with this conviction poses a threat to the child. before awarding any form of custody other than supervised visitation. You can do this for arrests as well by filing a petition to modify and ask the court to review the charges, but this really does mostly pertain to convictions. What happens in Philadelphia if someone has a 5329 crime, you ask the court to order a psychological evaluation, and the defendant will sit for that evaluation. It's about 45 minutes to an hour. I say defendant, the other party, and they will report, they'll talk about this crime, they'll talk about how they've rehabilitated themselves, and it's all voluntary information that the other party is giving up. Just had a question about who pays for the evaluation. I believe it is the other party, the party who is undergoing the evaluation. But to be honest, my clients have never paid for one. And I really don't know if it's the court, since they're the ones ordering it and managing it. Our evaluations have been down due to COVID, and the court hasn't had a psychologist on staff for a long time. I don't know if any of my fellow PLAers out there know the answer to that, but I think I'm blissfully unaware, since my clients don't have to pay for much of anything.
This is another one of those things that differs from county to county. I know in Allegheny County, this was a huge issue because they were trying to make our clients pay for psych evals or split the cost of it, even if they were IFP. So I think this is, an issue that at least some people are still seeing in Pennsylvania, and, maybe a case will come up that's ripe for appeal, and we can make sure that our clients who are indigent aren't having to pay for something like this, especially if it's for the other party.
So some of the key crimes that we wanted to point out are, of course, endangering the welfare of a child. It's a bit of a no-brainer. DUI and certain drug possession crimes, all of the interpersonal violence crimes or crimes against a person, terroristic threats, stalking, aggravated assault, not simple assault at this time, but false imprisonment is included. Contempt of a court order or agreement. You can see this come up where the parent has a conviction for violating a PFA. Strangulation was added to this list of crimes just last August. And
if I may, interrupt just for a moment. I'm going to launch the first of the CLE poll boxes. Attorneys on the call, please respond. You have to answer both poll boxes. This is the first of two, and it will be up for 2 minutes for you. And Sarah and Amber, please continue.
We had a question if this includes criminal or juvenile convictions as well. I think that would vary depending on the conviction and depending on whether the program that it was in. In my opinion, if it was a juvenile conviction that was expunged or has been sealed pursuant to like a delinquency program or some kind of alternative resolution, then it shouldn't count. But if it's a criminal homicide conviction from juvenile and I have access to that information somehow, I will use it to benefit my client. Amber, do you have a different response?
No, I agree with that. My only 2 cents is that if it's something that is really old, the judge, it might not carry a lot of weight. So I would just, take that into consideration. However, if, your party is very young and it's a juvenile conviction, it might be more relevant.
And in going along with that about what's really going to make a splash with the court, as I was starting to say with the reports, these are all things that, parent who's being evaluated has control over what they're reporting. And if they present very well, you're going to be, at the end of the day, reading a report that's not as satisfying as probably reading the facts of the underlying case. So it's a good idea to get a certified criminal record and see if the court will permit you to read those facts into the record, so that it's known what really went on, if you do need to have illustrate what that incident entailed.
Yeah, you might not want to create a beautiful comeback underdog story for the other party if it's pretty clear that that's what's happened. Although it might be really fun to, go online and see that there is a criminal record if it is really old and the person's made a lot of progress. It might just kind of tick the judge off to bring it up and try and paint them as who they were. So it's a lot to consider. And I would also definitely always talk to your client about it before bringing up anything from the past that especially is that heavy. And also look at their criminal background if they have any. They might have been involved in the incident that the other party has charges for. So I would always talk to your client about it too.
That's a good point. They might have been involved, or it's always embarrassing when you're making a big stink about a criminal conviction, and something that happened to me once. I didn't ask my client appropriately whether she was aware of this conviction or was around when it happened. And the defendant, he said, she knew about this conviction. She met me in jail. And that she was visiting him and they started their relationship while he was doing time for the specific crime. So do make sure that you vet your client's answers and make sure they what they were doing around the time those crimes occurred. And the same thing goes for crimes that are not 5329, but it is just other criminal behavior you want to make the court aware of. You won't get very far if you're making an argument that this dude was stealing drugs the whole time, because and now it's an issue to client, but when they were together and she was aware that he was in and out of jail and dealing drugs, it's not going to show very well to a judge. So yeah, just some more on 5329 and that the court has an obligation to do an evaluation and appoint a counselor and determine if further evaluation is necessary, and really keep an eye on if this particular crime poses a threat of harm to the children. Another special issue that I had no idea of before becoming a family law attorney is relocation. And it really sticks out to me because it's an obligation on every parent, whether or not you are or have been involved in custody litigation. And I think that if we were to poll non-attorney parents, non-family law parents, they just would have no idea what I have this obligation. So in short, each parent is obligated to file a notice of relocation if they are going to be moving somewhere and changing the residence of the child in a way that significantly impairs the other parent's ability to exercise their rights. So clearly that is very broad language. There's some case law on what a significant impairment to relocate or to exercising custody means, and of course it's going to matter whether this parent they see the child every summer or once a week, something like that. If you can continue to meet up at custody exchanges on time and the other parent can be involved in school activities, probably not a relocation. But typically in our office, we err on the side of filing a notice of relocation if it does seem like there could be a strong argument that this relocation was done and it was never filed. because if you don't file anything, you're leaving your client open to sanctions and punishments for making that change unilaterally. So when you file a relocation, you serve it on the other party, and there's paperwork in there that they can fill out to say whether they consent to the relocation or they do not. And it's similar to the custody factors in that the parent must show that the change that they want to make in residence is in the child's best interest. And there are factors in the relocation statute as well. If primary custody, if the regular custody factor best interest determination has not been made prior to the relocation, that must be done first. And we must establish who will be the primary custodian before the relocation request is addressed. As I've mentioned a few times throughout, you can also file a petition to modify. You can file a petition to modify as much as you want. You could just carry this on until the child turns 18. I mean, it's a good thing that a custody order can always be modified, but in reality, that means that parties are dragging each other into court pretty frequently. So you want to make sure that an order that you get can really be sustainable for that family. Obviously, as children age, their needs become different, and families should know that they're not obligated to come back to court. If they can come to an agreement, ideally in writing, right? We would advise them to do this all in writing. But if families decide this order is no longer working out for us, and they just kind of over time stop following it, and they have some other arrangement between them as parents, as private parties, that's perfectly acceptable. That's especially good for little things like, hey, we both moved, and now we're in this other neighborhood, and we don't meet at that particular Wawa anymore. Now we want to meet at this other place. That is fine, and it depends on the relationship between the parents and whether or not you're going to find yourself in a contempt issue, or some other kind of like petty filing back and forth. So it can be useful if you want to make some of those logistical changes if you have a very heated relationship and you want things to just all be in writing, and that way they are all enforceable. But otherwise, it's typically used when there's some kind of major change in the child's life, or a parent is seeking an increased time with the child.
Yeah, I know this is something that law school does not prepare you for, is drafting orders. And it's funny, I look back on, I've been practicing for about three and a half years now. And I look back on like my first couple of orders that I drafted, and I'm like, oh my goodness. So I would always look to your colleagues, look at samples. Of course, I have like one that I always use now, but it has evolved so much in time. There's always something that happens in a case where you're like, that should have been in the order, or I'll make sure that's in the order next time, or I at least address it with the client. So these are things that definitely involve, and over time you get better at.
Yes. Ambiguity in an order is deadly. It's fatal. Because it's not enforceable then if it can be interpreted multiple ways. So you really want to be specific, and you want to read every order that you get from the court, because typos and other mistakes are common, and they do lead to confusion, which can lead to non-compliance. And that's a very unfortunate situation. We also have the ability to file for an expedited hearing. Expedited listings are typically very narrow. I'm not even sure if the court is doing them right now, at least in Philadelphia. There was a period of time where we weren't for a minute because of COVID. But it's typically a very narrow, very short hearing that is just about an issue that cannot wait for a typical like judicial proceeding. You must have personal service for an expedited petition because of how quick the turnaround is intended to be. Even though it is, we put in here 3 months, but it may be a couple of weeks, 6 weeks or something, and they need to know exactly, have notice exactly of what you're asking for in the expedited. The court will issue an interim order and then later schedule you for a date to with a judge to review what was determined in the expedited hearing. Similar to expediteds, we also have the capacity to file for emergency. You can file an emergency complaint and emergency modification, emergency contempt. I have come up with all sorts of different titles for my pleadings because you can file what you want. That's what one of my colleagues says, you file what you want to file. Typically in Philadelphia, emergencies are narrowly construed. The court will not accept an emergency unless there is an immediate danger to the child. So these are most appropriate. You want to be conservative with filing emergencies in Philadelphia, and it will be appropriate for a case where there is an allegation of child abuse or neglect or some type of imminent harm, or perhaps the child is being abducted, has been or will be abducted, taken out of the county, out of the state, or out of the country. Same thing with expedited. It's a quick turnaround. In Philadelphia, we will have sometimes have a ex parte hearing the same day as the filing, or you will have a rule date about 10 days after the pleading is accepted, and then both parties would be present at the rule date. Okay. This is not as fun as yesterday's.
Sorry, guys. It's very substantive today. No videos.
No videos, no horrible jokes. All right. As we've already mentioned, another filing in custody is filing for a petition for contempt and to enforce an order. This is something that I've had clients get confused about. They will say, so-and-so isn't coming to pick up the child. And you really want to determine, do we need to file something? Are you unhappy about that? Because the reality is that a petition for contempt, the spirit behind it is not to change the order that you have. That would be a modification. It's to enforce an order. So sometimes the client might be glad that the other parent isn't picking the child up, and so they just want to kind of lay low and maintain this status quo. Other times, the clients will be upset and they see how it does, hurt their child, and maybe, the child's emotions, or they get really disappointed, or they get really excited and then disappointed. So they do want the order enforced. So you just want to make sure that you are speaking with your client before filing anything to say, like, this is not a legal outcome of a contempt. We can't change this. We also can't make the other parent be better at being a parent or want to show up. But if you have an issue like a parent refusing to give the child back, or withholding, as we call it, or snatching the child, definitely want to be filing a petition for contempt, perhaps along with a modification. And as we mentioned before, in order to actually have the court make a finding of contempt, you must be able to show that the order was specific enough to be enforceable, so that there was no, plausible, ambiguity, I didn't understand this order, I was confused, argument. And if the court does determine that there was willful noncompliance with the court order, they have a few options for how to sanction the parent, including jail time. Typically, in my experience, the sanction is a slap on the wrist, and the finding of contempt itself is a black mark on their file for, the lifetime of their custody litigation. But it's, in my experience so far, has been rare to have a parent actually pay any money or go to jail. Typically, they just have to return the child, maybe forfeit some time, um, and that's that. Now, Amber, have you seen any cases where there's substantial sanctions?
No, I mean, and kind of unfortunately too, but I do feel like this is the time when you might want to ask for attorney's fees. A lot of organizations, I guess, might have different policies for that. It's weird to think about asking for attorney's fees because, we are free. But a lot of organizations, can get attorney's fees, and that'll be helpful, I think.
Yeah, the reluctance, I think I want to share a brief anecdote. I know I'm going kind of off, and I don't want to do that to you again today. But I do have an anecdote about contempt and how upsetting the court's reluctance to find people in contempt is. Even just a finding is valuable for the history of the case. And I had a case where a parent, the parents had decided that their child would go live with grandparents in Africa. And the father went to visit the child and removed her from the grandparents' home and took her to his parents' home or some other family member's home, and then proceeded to hide the child from family members and eventually mom, who made her way over to Africa and stayed for 8 months trying to find the child. She even went through the courts in Guinea, which is where they were, and Sierra Leone, and couldn't get any relief there. So she came back to Philadelphia, filed an expedited. We got an order for the child to be, the father wouldn't tell us where the kid was and continued to hide her. My client was very pregnant, and so she couldn't fly back to Africa. So the judge said, okay, you guys come back here in 30 days. Well, guess what day 30 days was? March 20th, 2020. So we don't go back to court. The father, we don't even know if the kid, made it here safely. We do find out kid is back in the US, but the child needs to quarantine. The idea is that they will pick up on their old Philadelphia order, which again, they appropriately decided together to not follow for a period of time. But now Philadelphia, they never lost jurisdiction. That order is back in place. But the father continued to withhold even after the quarantine period was up. And then he started making other excuses, like the child needed therapy before seeing her mom. And it was this separation between mom and child was exacerbated by the courts being closed, not being able to, file appropriate motions. We had an emergency that just wasn't even heard and was denied and consolidated with some other stuff. Eventually, their argument was that Philadelphia had lost jurisdiction. And I had the pleasure of speaking with a Ghanaian attorney for several hours. All of this is to say that after almost 2 years of withholding the child, hiding her in another country, and coming up with several different excuses about why he wouldn't turn her over, the court still decided not to find him in contempt. So it's a frustrating process. Okay, I just had to get that off my chest.
The judge isn't always right. We all know that.
Okay, a few more slides here on custody. So if a dependency action has been initiated involving the same child, that's in the case for custody, the dependency court takes jurisdiction away. They cannot have it at the same time. Once that, all of the pleadings are stayed, and once the dependency action is closed out, then the parties can pick right back up where they left off in DR court. Make sure we have enough time. We can skip evidence.
Okay.
Or I can just talk really fast. I don't know.
I mean, everyone has these PowerPoints. So if anyone has, I mean, you can see generally the topics that you want to pick up with co-parenting, or do you want to skip this?
I think we should just at least let people know about the pending legislation.
Okay.
If anyone here is a parent, they know about the co-parenting or parenting challenges during the pandemic. So this is not a repeat of war stories again.
The issues with laptops and yeah.
So there is a bill, there's two bills pending right now that are important to know about. There's Senate Bill 78, which is Caden's Law. The ACLU and the Support Center for Child Advocates and a number of other like youth agencies have come out against this bill. It would make mandatory that would make it mandatory for any person who has a finding of abuse or an abuse conviction to have supervised visitation, whether that's the parent themselves or somebody else in the household. Even judges are upset by this bill because it strips them of their decision-making ability, because it is, again, a mandatory supervised. And that bill is making its way through the legislature now. It's kind of tied up in politics, attached to the statute of limitations bill for sexual assault survivors. But that would have a tremendous impact on custody litigation if it were to pass. And then the other one I really want to point out is the family court reform, which I mentioned earlier. That would make a constitutional amendment to make the entire state of Pennsylvania a one family, one judge state. And also to hear cases like in a triage organized by complexity, like do we have DHS involvement, do we have criminal history, and really address them in that kind of hierarchy of issues.
That bill in the middle, I think, would the squatters bill, House Bill 823. It made a comeback. It was House Bill 365 originally. But basically what this bill is trying to accomplish is giving police officers, I think, more power to evict unauthorized occupants. This could have a huge impact on, our clients that might not be, they might not have a property interest in where they're staying. They might not be on the lease, but maybe they've lived there for years. And it kind of would allow for officers and just persons to sidestep the court system, I think, and with just an affidavit from the owner of the property, evict people that they say do not belong there. So of course, just like anything, there's pros and cons, but I think that one we really need to keep an eye on, because I think it would have more cons potentially for our clients. And that is a great segue into protection from abuse actions. I'm sure everyone is familiar with this power and control wheel that I have prominently displayed here. I did choose the one with the bright colors and the illustrations. But basically the power and control wheel, and I'll change this slide because I have another one too that's less fun. There are several different versions of this. I find it helpful to show to clients It does a really good job of illustrating what an unhealthy, abusive relationship can look like and how you can really get stuck in this power and control wheel that keeps on spinning. So sometimes you might have a client come in. I know I had a client once that came in with a black eye and just didn't want to talk about it. She was there for a landlord-tenant issue that involved, not her abusive partner at the time, but her landlord actually charging her for damage that was done after an incident that she had with her abuser. But I showed her this wheel, and she didn't think of herself really as a victim or a victim survivor or a survivor at all until I showed her this wheel. And then she was like, wow, that's happening. And that's me. And that's what he's doing. So this can be a really powerful tool to get clients to kind of see their situation for what it is and to realize, what might be coming next and what to look out for. So it can also really be used as a good safety planning tool. Now, there are all different types of safety planning. You might want to plan for emotional safety. That's something that I think a lot of us don't really think about. We tend to focus on the physical aspects of safety planning. But these are things like having a support system, maybe engaging in therapy, thinking about what types of activities help a person to feel better. So our survivor clients, really do need to focus on their emotional health and not just their physical health too. But another aspect of safety planning, I'm just going to read these questions. They're things you might want to ask your client. Can you stay out of the bathroom or kitchen during an incident of violence? And reasoning for this, as I'm sure you can imagine, the bathroom and the kitchen are two of the most dangerous rooms in the house, statistically speaking. There are hard surfaces, sharp objects. A lot of our clients, they'll be pushed, shoved, hit their heads. I've had a lot of clients with TBIs. So we want to encourage them to, if there is a physical incident, go to a safer room in the house where there are softer surfaces. Having an escape route, keeping your keys or your purse in the same place all of the time, and important papers too. Lots of our clients lose very important items to their abuser. Maybe they know where they keep their phone, where they keep paperwork, their social security card, banking information. And then we end up in situations where identity theft is at play. And if we can come up with a plan to safely store these items and quickly, take them once a person needs to, that's important, and it can prevent a lot of future headaches. Where will they go if they need to run? Do they have a phone hidden? Things like that. There are also special considerations for children. Talking to the children in an age-appropriate way, of course, about the situation, especially if there is a PFA that is being filed, what that might mean for the family. Teaching your children how to call 911 if they don't already know how to call 911, knowing where to go, knowing when to hide, and just having a plan. That's what safety planning is. It's the plan that we have that we hope we don't have to use, but if something happens, your client will be happy that they had a plan. So the Protection from Abuse Act, and we already had a training on this, so I'll be pretty brief with it. But under the PFA Act, there is a relationship requirement. So you can't file a PFA against that person that cut you off in traffic, right? There needs to be some sort of a relationship, and that includes people who are blood related or related by marriage, and the parties can be separated or divorced. Parents and children, OBOs, are petitions filed on behalf of another person. So if, of course, a parent or guardian can file on behalf of their child. Other blood relatives and relatives through marriage and adoption are okay. Current or former sexual and intimate partners. And that does include even just dating relationships. Same-sex relationships, of course, count as well. And other family relationships have counted, and there's a lot of case law surrounding this. I would encourage, if you're having trouble with your PFA department accepting a PFA petition saying there isn't a relationship, to look at the case law. And so PSVIs, which I'm sure many of you are familiar with, they don't have this relationship requirement, right? And a PSVI is a protection from sexual violence and intimidation order. So this includes things like sexual assault of adults and children. So say you don't know the perpetrator, but you want an order of protection that says that this perpetrator can't have contact with you. The PSVI would be the way to go. This would also cover harassment of minors by adults and stalking of minors by adults. So again, if there isn't a relationship requirement, or if there isn't a relationship rather between the parties, you might want to consider if there's sexual violence or some form of intimidation, because you could file for a protection order under this act. I am not going to read the entire definition of abuse under the PFA Act. I'm sure you've all seen it before, but I will say this presentation has been a lot of going back to the basics, and it's important to go back and just read the law every now and then. I think even if you've been practicing for a long period of time, it's kind of like athletes. I won't pretend to be an athlete, but you know, you practice layups for a reason, right? I'm assuming. So the protection from abuse, the procedure for those types of actions, sometimes it starts with an emergency petition for a PFA. It doesn't have to start this way, but typically courts will have specific time to file temporary petitions. Maybe that's Monday through Friday, 9 to 11 o'clock, or you know, whatever your court does. But during those times when you can't go to court and get a temporary order, whether that's at night or on a weekend, you can go and get an emergency PFA order. One thing to be aware of, however, the emergency PFA will expire. As soon as you're able to get that temporary order, you really need to go and do that, and make sure that clients understand when the emergency PFA will expire, and that they need for that emergency order to be replaced with the temporary order in order to keep their protection. So the temporary order for protection is obtained through an ex parte hearing. It's typically extremely brief. There's a lower burden of proof, and you end up, if you're granted with the order, what's sometimes called a 10-day order. So within 10 business days, there's a final hearing scheduled. Now, in order for that hearing to take place, the defendant in the action needs to be served with a copy of the petition. There's another slide on that, so we'll talk more about service. But at the final hearing, there's a number of different things that can happen, assuming that there's proper service. Maybe the defendant will consent to the order. They say, fine, I'll stay away for, up to 3 years or however long. They might not show up. There might be a default order, in which case your client essentially gets what they want. Some counties have orders that are non-PFA civil consent agreements. Not every county has this. Philadelphia doesn't. I know that Allegheny County does, and they're very popular. Big difference between these types of orders and PFAs. The non-PFA orders obviously don't carry the ICC or the contempt charge, which is a pseudo criminal charge for if they're violated. It's so important to talk to clients and make sure that they understand what their rights are if this type of agreement is violated. Often I've heard people say, I have a PFA, why aren't the police enforcing it or doing something about it? And it turns out it is not a PFA, it's one of these. But they can come in handy, I will say, for things like resolving custody issues. At least in Allegheny County, you can put really anything under the sun in this type of order, and they're generally approved and signed off on by the judge, because you're saving them from having a hearing, and they like that. So ultimately, you'll either end up with some form of order, final order, or a dismissal, and that is, unless the case is just perpetually continued for whatever reason, which we all know does happen. For a temporary order, you could end up with the judge hearing your side of the story and saying, you know what, I don't think that this rises to the level of warranting a PFA to be ordered. So your client might get a hearing date only. That is a red flag if you see it, because it means that right off the bat, the judge doesn't think that you are going to meet your burden of proof. There might be protection only. You could ask for eviction and exclusion from the residence, no contact, relinquishment of weapons. And there was a whole presentation on relinquishment of weapons, Act 79, so I won't recover that. The order could also cover custody, which is huge. Things like financial support and reimbursement for economic losses due to the abuse. I don't know about you, Sarah, but it's very rare that I find a judge ordering reimbursement of financial losses.
Yeah, I even tried that today. I imagine if you have some receipts of, like co-pays, and it's some egregious kind of medical bills from some very clear, obvious injuries that were sustained by another person. But today what I asked for was reimbursement for the defendant being unjustly enriched by just holding on to the stimulus payment. And not giving, when they were together, they had filed jointly, and he got the entire payment, including payment for her child. And the court denied that request. So, but it's worth trying. And as you said about, look through the definitions of abuse always, I always go through 6108 and I check, all right, what relief am I really asking for today? Because you do you and your client a disservice if you just get in the motion of asking for final order with eviction, no contact. You want to really make sure you're using what you're eligible for under the law.
Right. And you mentioned reimbursement for medical expenses due to an incident of violence. That's something that can also be covered by victims' comp. So, even if you're not successful through the PFA action, there are other avenues to make your clients whole. So definitely don't forget about those. Service issues. How are we looking on time? Because I could talk for a while about service issues. In a nutshell, I'm really bad at putting things in a nutshell. Defendant needs to be served. Often police or the sheriffs can aid with this or are supposed to aid with this. Every county's different. I know in Allegheny County, typically 3 continuances are allowed for lack of service. And typically the hearings are relisted pretty quickly. I have found thus far that Philadelphia is a bit different. They're more lenient, and I think their continuances, where Allegheny County might look like a couple weeks due to lack of service. Sarah, correct me if I'm wrong, but I've been seeing a couple months. So I think in some counties you have ample time to at least do everything that you can to get a person served. I've gone as far as to attend criminal proceedings to try and make service happen, but sometimes it can be a hindrance. So
Yeah, I would always advise on using law enforcement or sheriffs when you can, depending on the county, depending on the local. You might have a really good experience, or you might be, having the door shut in your face a lot. And as far as timing goes, I was just asking my supervisor about this today, because the rules on personal service require that there be a reinstatement or a reissuance of service if you miss the 30-day, 10-day, 30-day, or 60-day window, depending on where the defendant is. But each time you come back to court with a service issue, they essentially reissue the temporary order, or temporary order for PFA stays in effect, and that, I guess, starts the toll again. For timing, but I haven't had any issues in Philadelphia, and the last case that had a service difficulties was continued for almost a year. So there's a lot of leeway.
My advice is always tell your client, or we do these so often, sometimes it's hard to remember the basics and things that so well. You might forget to mention parties cannot serve their own PFA. Besides it just being dangerous, it's not proper service or persons related to the party.
We also had a question come in about what if the person is purposefully evading service. You want to obviously document all of your attempts to serve, use a process server, and document all of their attempts. And use police if they keep moving around, you don't know where they're located. Eventually, once you show the police or you show the court you've made all these attempts, you can ask for special service or alternate service, at which point you would mail a certified copy and a regular copy of the pleadings to the defendant at their last known address. And with that court's permission for alternate service, that should hopefully be sufficient.
Yeah, that's a good point. And we do see that a lot. And it can be really frustrating, especially for survivors. They feel like they're, getting away with it. So we do want to make sure that we exhaust all of the resources that we can. Weapon relinquishment. So this is covered in another presentation. It was covered very thoroughly, but just briefly, when a defendant has weapons, you file an attachment A. It's a form with the court that says, what those weapons may be or what they are and where they might be found. Typically, you'll also list the defendant's contact information, really any information that can help the police locate the firearms so that they can be relinquished. However, if you do have a defendant that's saying, no, I do not have firearms, you might run into some issues enforcing this. Switch to this one. So Act 79, which, like I said, was discussed, it switched things up, and now if there is a hearing, so if there's a finding of abuse, It's no longer up to your client if they want to pursue weapons relinquishment. The defendant must relinquish their firearms. If there is an agreement, however, if there's no finding of abuse, but there is like a final order, it's really up to the court's discretion. But if there is a hearing, again, they must relinquish. So, as I'm sure we all know, PFAs can be entered for up to 3 years. Of course, you can agree to or have ordered, any period of time less than 3 years. Judges might say, I think these parties just need a cooling off period and order a pretty short period of time. And you can file to extend a PFA before the expiration. But you have to show that there was a new incident of abuse or continued risk of harm. So just keep that in mind. You don't have to wait until the PFA expires. You can file before its expiration to extend. PFA violation. So clients should be keeping a copy of their PFA with them at all times. If there is a custody order involved, it might be a good idea or is a good idea to make sure that the school where the children attend has a copy of it as well, that they know not to allow the children to go with the abuser, things like that. If there is a violation, I tell clients, call 911. If you feel unsafe, call 911. It's better to be safe than sorry. And by calling, there's a record that something occurred. Speaking of having a record, always, keep a detailed journal of any incidents that occur. You might want to follow up with a police report. I know in Allegheny County, sometimes ICCs are filed kind of automatically for violations, whether that be a call or a text received from the defendant. Sometimes our clients have to be a little more vigilant. They might need to go to the magistrate and file an ICC themselves. I always encourage clients to ask the officer to do it. They might not realize that they can do that, quite frankly. So I always encourage clients to speak with an officer about that. And of course, if there's a violation, consider a petition to extend the current order. Sometimes that can be automatic. Sometimes, maybe it isn't something that turned into an ICC, but it's enough to support a petition to extend or modify the current order. So those are options that you want to consider. Child support in 7 minutes. So it's taken me an embarrassingly long time to get this straight. And I think I still fumble sometimes because I don't practice a lot of child support, but the person that is filing for support is called the plaintiff or the payee. The person that's ordered to pay the support is called the defendant or the payor.
I have a tip for you.
If I can just launch the second CLE poll right now, attorneys, you must respond. For CLE credit, I will leave it up for 2 minutes, and please continue, Sarah and Amber.
My tip is in remembering those, because I struggle too with like obligee, obligor, like what? The EE, you think like, oh, employee. And if you're the employee, like, I don't know, you're the one getting the money. So that's my tip.
I like that tip. So hopefully others don't struggle as much with that as I do, but so who's entitled to child support? Anyone who is raising a child can file. Third-party custodians They can file for child support, and you can file against one or both parents if you're a third-party custodian. The child that you're filing for support for must be either under the age of 18, still in high school, or there is case law that says that you can get support for a child with special needs who is over the age of 18, and that one is pretty fact specific. So if you have a case like that, you probably want to refer to some case law on it. And a parent can seek child support from the other parent regardless of the financial situation of each parent. So even if you make more money than the other parent, if you have the children the majority of the time, it might still make sense for you to file for support. So what the process looks like, it's a lot of data collection and a formula, a lot of numbers. So at the support conference is kind of the initial meeting that starts off the action. It's where you bring evidence of earnings and expenses, things like childcare expenses, if the children or child attends private school, what that tuition looks like, who's paying it, if they're in extracurricular activities, if there are medical expenses that the child has incurred, utilities, mortgage and rental payments that the plaintiff makes, really any payments that that a parent or guardian is making that affects the children. They should be prepared to have receipts, things like that at the support conference, tax information, that sort of thing. Typically there's a list that the hearing officer or master will send out telling you what they require you to bring. And you should make sure that your client has as much of that information as possible. So in order to determine what a party's obligation is, there are different things that are taken into consideration. So if the child or children have special or extraordinary expenses, that could look like medical expenses that are particularly high. Maybe they have some kind of medical condition, or if they're in a big fancy private school, they might have high tuition. So this, it's very fact specific. Physical custody, which parent has the most overnights, of course, and if one party has unusually low living expenses, that might also be considered. If he or she shares living expenses with another person, things like that could cause a deviation. The court will also consider if the defendant or the payor has extraordinary expenses, like if they themselves have medical bills they have to pay or other children that they're supporting. So sometimes, unfortunately, you hear about defendants incurring debt to avoid obligations. This does happen. If this happens and the plaintiff picks up on it, then they can ask that whatever purchases were made to, make it seem like they have less or to avoid an obligation, the sheriffs can actually sell those belongings as part of enforcement of the order. So support guidelines are listed under the statute. To figure out a parent's net income, you start with their gross income and subtract their taxes, Social Security payments, unemployment compensation taxes, local services taxes. So you can read what they subtract there to get net income. This is important to note, especially for our clients. Cash assistance and SSI benefits are not counted as income for purposes of support. And the amount of child support owed by the parent who does not have custody, it depends on the percentage of the combined income that the parents earn. And that's why it really doesn't entirely matter if there's a large disparity between both parties and what they earn, because they put that amount together to determine the obligation. In support matters, paternity can sometimes be an issue. DNA lab testing might be ordered, and the cost of that testing can be assigned to either party, but typically it is assigned to the father if it does turn out that they are the biological father. And I realize I have like 1 minute left. So I think I'll wrap things up, but we do have some more information about support appeals enforcement. I encourage you to check that out if you do child support, some more considerations in pandemic relief. Thank you for listening. And Sarah, if you have some closing remarks.
Nope, just thank you all so much. Thank you for being active in the chat and getting us your questions. Feel free to email us, and enjoy the rest of the conference.
Sorry about that. My mouse went rogue. I couldn't get it to unmute myself. Thanks everyone for joining us. We'll see you again for tomorrow's session. Sarah and Amber, thank you so much for presenting for us for 2 days in a row. We appreciate it. And have a good rest of the evening, everyone.
Thank you.
Thank you so much.